My name's Eric van der Vyver, or Van der Vyver as they call me in the States. It's new for me, I can hardly ever recognize them when they call my name. I'm going to give you a brief just introduction essentially on South African patent law, because contrary to popular belief, over and above having fair and equal elections and hosting major sporting events, we also protect intellectual property. So South Africa is a member of the PCT. We've got a 31-month filing deadline, although a 3-month extension is available as of right, and you can apply for the extension at the same time as applying for the patent, so it's not necessary to actually do anything up front. There are no excess fees payable, so number of claims, number of pages doesn't matter. The major reason for it is that the Patent Office will not read the specification, so they really don't care how much you put in there. Because a lot similar to Singapore, South Africa is a non-examining jurisdiction. I noticed that Singapore refers to as a self-examining jurisdiction, which I think is actually quite a nice description, because that is essentially what it does. It places the onus on the applicant to make sure that the application that is before the Patent Office is in as patentable a format as possible. There are various procedures which allow for this to take place, and one of them is that amendments are relatively easy to do, and they can be made at any stage during the life of the patent. Before the acceptance of the patent, you can even make broadening amendments to the claims. After acceptance and after publication, you can still make any amendments as long as they fall within the scope of the claims as originally filed. The amendments obviously do pose an additional cost. They are normally not exorbitant, they're very minimal, particularly because the amendments would normally have been made in foreign jurisdictions, other jurisdictions. So it's normally just a case of bringing the South African claims in line with the examined claims in the other jurisdictions. Acceleration can be very effective in South Africa. There's a very quick procedure. It's basically possible because they don't get examined. So if you want your application granted very quickly, it's quite easy to do so. As long as you fulfill the formal requirements, all your declarations and all the rest have been filed, you can have your application accepted within a question of months. 1 to 3 is normally the benchmark. After that, it will be published within a further 2 months, and you can have a granted patent as quickly as 4 to 5 months after you actually file the application. If you're very confident of your patent application or your patent specification and the patentability thereof, it therefore makes it a nice vehicle if you want to test your patent, or you want to actually test the strength of the patent in South Africa via litigation. If there is infringement, you can enforce it very quickly, and the patentability of the patent will normally then be looked at during the investigation of the infringement proceedings as well. So it can be a very quick procedure, and and quite effective and quite cost effective, as the cost for litigation in South Africa is substantially less than a few other jurisdictions. It is normally suggested that you slow the acceptance process down. This is quite a simple procedure. You just apply for the delaying of the acceptance of the application. The major reason for it being to allow you sufficient time to have your examined patents in your other jurisdictions proceed to grant, so that you can see what amendments need to be made to the claims to also affect them in South Africa. You have an automatic 18-month extension as of right, then a further 3-month extension, and then any other extension can be granted on good cause shown to the Patent Office or to the registrar. Good cause includes awaiting the outcome of a prosecution of corresponding application in examining jurisdiction with a view to making amendments. It's very important to note that a failure to bring the South African patent into a patentable format can be very detrimental to you at a later stage. There was a recent decision, recent about a year or two ago, where the court held that there was a culpable delay in bringing the South African application in line with foreign examined applications, and as a result the court refused the patentee the right to enforce the patent at all. So it is a crucial thing to keep in mind. Luckily, it's not only your job, it's my job as South African attorney to remind you that you actually have to bring the South African patent application in line, and we will do that by monitoring your foreign applications as well. South African law, patent law, is based to a very large extent on UK law, so we tend to follow the UK quite closely. Our courts have not made any rulings on the patentability of software, although we expect to go very much a similar route as the UK. Business methods, although you will get a patent for it, they will not be enforceable. They are not considered to be patentable. It's interesting, I actually saw a patent the other day in the patent journal for a hamburger. And I don't know who filed it, but obviously it went through because it wasn't examined. We found the inventor and suggested that they also file in the States. Might make some money off that. There are no formal disclosure requirements. As I said, the most important thing is that the applicant is expected to remedy the defects and claims based on its foreign prosecution. And I've already mentioned that. Relevant markets for South Africa. Obviously, mining is a very big industry. The communications and IT, especially wireless communications, there's a massive explosion in wireless communication in Southern Africa as well as the rest of Africa, and it's definitely a very lucrative market to enter at the moment. Probably evidenced by the fact that one of our local cell phone manufacturers or cell phone service providers is currently become a sponsor of Manchester United, so they must be doing well. There's also a low-cost banking explosion, especially from the cell phone side, cell phone banking, so that's a very active industry. Then obviously healthcare, biomedical devices, banking, agriculture, and very importantly, South Africa is seen at the moment as the gateway into sub-Saharan Africa and also the rest of Africa. So our firm deals with patent and trademark applications throughout the whole of Africa. It can be notoriously difficult to deal with a few of the African countries, and we've set up a network which allows us to do that within reason. And I think the most important thing is before you file in Africa or anywhere throughout Africa, just take advice from someone who knows the landscape a bit better. There are certain countries that you should definitely file in, some which are notoriously difficult to actually get your protection and to enforce your protection. And I think that's pretty much it. Just quickly, thanks Eve, and thanks for Kim for organising. And yeah,